year, but I think it's
No,
good for
I want somebody that has one right now. You said,
For 4
you have
years.
a driver's license over here, what happened here? I lost my place here. Tommy, you said you have a driver's license, right? Okay, how many years is that good for?
I have to renew mine every 2 years because I have a CDL, but I don't use it.
Okay, but
But not for
yours
like
is
4
good
years.
for 2 years. Is that what it is in the state of Virginia? 2 years?
4.
4?
I'm in South.
Okay.
I'm in South Carolina, but I think it's 10 years without a CDL.
Okay, well, but I was just told it's 4. I know in California it's 5 years. Okay,
I
because
think
I
it's
used to
also been
have one years
7.
ago
It's
too.
also
I
been
was like all of you. I thought, man, here I am driving a damn truck on the farm all over the place. I mean, a big old truck. Never had a driver's license, but suddenly now, because I'm getting to be up there to becoming a teenager, I thought, man, I better get down and get myself a driver's license so I can go out and drive on the street. Now I was driving my motor scooter, my motorcycle on the street anyway. Never had a driver's license. Never thought about it, you know. But the fact is that, yeah, it was 5 years. But here's the point. The point is that it's good for a certain amount of time. Roger, you did the right thing in what you did. You rescinded your signature because you were coerced into getting it because that was how you believed you were supposed to act and how you were going to be a good, law-abiding citizen. And I was hooked up in the same thing before I learned all this stuff too, and it took a very, very long time. But the point I'm making is you have the most important thing you have is your signature. And remember something else. Every time you give your signature, you have created a contract or entered into one. If you give your signature on their contract, you have entered into their contract. If you create the contract with your signature, it's your contract and not their contract. And there is all the difference in the world. Because your contract is a personal contract and theirs is not. That's one of the main reasons you want to take their authority away from them and let them sign your contract. Your contract with that counter offer gives you the contract. You're the creator of the contract. Now, bear in mind that when you create a contract, you also create something else. If you have created a credit contract of some kind, you also create, for example, let's say with your phone company. If you write a check for that deposit, they can demand that you write a check for every bill that they send you. If you come back to the phone company and they sign your counter offer where you're going to give them more money, it's your contract, and how are you going to settle it? You're going to do the same thing you're going to do with anything else. Ladies and gentlemen, you prepare over the weekend your paperwork and you take it to them. Now they're going to balk at it. Right now, they're going to say, well, this is not lawful anymore. Yes, it is. It is lawful. If you're trying to make a settlement to your doctor right now, they're going to put it on hold. It's not going to be settled right away, but they're going to put it on hold. But guess what else they're going to do? They are not going to turn you into a collection agency, because if they do, you're going to file a notice of what? You're going to file a notice of claim against them or a counterclaim. Why? Because what you have done is perfectly legal and lawful, and it's on the books and upheld by the Supreme Court. And we're going to get into that a little bit deeper in not the next class, but the one after that. We're going to show you some documents and some court rulings, which will bring you right smack dab jaw dropping to your knees, saying, my goodness, this really is happening. A lot of people don't understand that this is real. I've been doing it for years and years. Michael Reed and the rest of us, we've all been doing that. And it's always worked. Right now, thanks to Donald Trump, and he's done a good thing, so don't get all upset with old President Trump now because he joined the IMF and the Treasury Department and the Federal Reserve under one roof now. Okay. At the end of all this, when all things is up and the processing center is open, believe me, you're going to be damn glad he did. Because all your paperwork is going to go one place. You're not going to send this one over here, this one over there, and you're not going to send the one to the IRS or any of that stuff anymore. It's all going to go there, and it's all going to be taken care of. Because at that processing center, IRS has their own screen right there. So when you send your 1099A copy B in, it's going to go on the screen, even though the IRS has not received the original, the red copy, Part A of the 1099A. It's going to go on the screen right then and there. So it's 2 weeks advance from you having to turn around 2 weeks after you've made the settlement and send it to the IRS. Anyway, it's only going to be better when it gets up and running. And believe me, I'm like everybody else. I'm anxious and I'm waiting, but we don't have any choice in the matter. There's no sense in cutting off your nose to spite your face. And there's no sense in bad mouthing and sending all kinds of nasty letters and stuff to the IRS when your actual remedy is through them. They're the ones, if they don't do what they're supposed to do, and you file a 1099-C, let me tell you something. Ladies and gentlemen, whoever it is you file that C against, you know what C stands for? Cancellation. You're canceling the debt that they owe you when you file a 1099-C. The IRS is going to go after them lickety-split because they didn't do what they were supposed to do, and they are in big doo-doo themselves then. But we're going to go through this process step by step so you get the understanding. It's the same thing with the 1099 OID, the 1099 MISC, the 1099 LTC, and so on. Every one of those things are a process of its own. And we're going to take you through each one of those processes so you understand when you use this one and when you use that one and how you use it, because they're used different. The steps are pretty much the same, but they are nonetheless a little different. They have their own paperwork that goes with it. They have their own protocols that goes with it, and so on. And protocols is something you have to learn in every process that you do. Right now, I'm teaching you the protocols of non-judicial claim or counter offer or whatever it is that you're going to go after somebody else for that has injured you in some way. Okay? Because you are first and foremost the injured, damaged party. And remember, if somebody injures you or damages you, that is also a criminal offense. They don't have a crime without having a victim. You are a victim because you have been injured or damaged. There's all kinds of injury, not just physical injury. There's emotional injury. There's traumatic injury, all kinds of injury. And we'll get into that when we start crossing that bridge. But right now, does everybody here have an idea on what we're talking about when we're talking about your motor vehicle and how to obtain it? That's the first thing. Secondly, let's go back to this police officer that stopped you now, okay? Now, he's already told you had a broken tail light, and he's going to give you a citation. Accept it, and then go and get it fixed and take it to any police officer and show them, here's the citation, and here it's fixed, see? All right. Now they can see that the tail light's fixed. You had to maybe take a few steps, but actually it's for your benefit as well. You don't want to be driving around with a broken tail light, shining your bright light every time you step on the brake in somebody else's face, and they're going to run into the back of you. Okay? So it's a two-way street, ladies and gentlemen. Let's act that way, okay? Let's choose the battles we fight and choose the avenue we're going to fight on and the arena we're going to fight in, okay? So the point I'm making here is you make your contract, do whatever you can to abide by, without creating and raising all kinds of problems with the officer that stops you. There's no need to call him names and do all those kind of things. Be polite. Be the people you are. If you're a personable person, you're a Christian person, you're a God-fearing person, act that way. Live that life because that's who you are. Why would you let somebody take you out of who you are and put you into their world where they're running roughshod over you and calling you all kinds of names? You don't repay. The Bible says don't repay evil with evil. Well, don't turn around and do the same thing that they're doing. Don't live like they are. You live your life the way that you live your life. Okay? You're trying to live your life. You got families to take care of. You've got work to do. I mean, you're doing things in life, and that's what you want to do. You want to continue, and you want to do it in a peaceable sort of way. What we want to do in this assembly is take back everything that was taken from us. You can start by doing your part right now. Live the life that you want to live, the life you are living, and be yourself. And don't get out of character because somebody else wants to throw a monkey wrench in your soup, okay? Just don't eat the soup. I mean, don't worry about pulling the monkey wrench out. Just don't eat the soup. Let them keep their monkey wrench in the soup. All you did is gain a monkey wrench, okay? You understand what I'm saying, I hope. With that being said, when you get done with that police officer, you have done two things. You've accommodated him. He's given you what he needs to do, and it's for your good as well as theirs and the public's good. When you come to a four-way stop sign, it's best for you to stop and yield the right of way. It's only common sense. Yes, it's their law, but it's a law that you need to abide by. That's for your protection as well as everybody else's. So we want to act that way. Now, what happens if you get a police officer that has pulled you over and suddenly this guy jumps out and he's all grumpy and cranky and he's going to just throw the book at you and do whatever he wants to do, he's going to do, all right? That's a horse of a different color, and you have to deal with that officer in a different manner, okay? So when they start doing things, you are taking and you're asking your questions, you're giving direct answers to direct questions they ask you and not volunteering anything. If they tell you they want the window rolled down all the way, roll it down all the way. Now, if he reaches his hand in your vehicle after you roll that window down, now he has violated your space and he has also committed a crime against your person. And you make a mental note of that, and later you write that down as soon as you can, because you're going to turn around then and you're going to file a counterclaim or a claim not only against him, but let's say he takes you in. Let's say he removes you from your vehicle and puts you in his vehicle. Now, suddenly, your vehicle is either going to stay there, but he's most likely going to call and have it towed. That creates a charge against you for a towing charge and a storing charge. You see how these things compound? If you let it get out of hand, that's what's going to happen. Yes, you have a claim, you have an action, but you've got to take that. Those are all hoops that you got to jump through that hopefully you don't have to. Being polite, if somebody is all upset and hollering and screaming, and you're giving honey back to all the lemon that's being thrown at you, you're going to win more with the honey than the lemon. And at the end of the day, that person will calm down and see that you're not trying to intimidate or hurt or harm them in any way. Doesn't always work that way because you've got a lot of hotheads out there that are wearing badges that should never have a badge on. Unless it's a prison badge somewhere. But that's beside the point. The point I'm trying to make is you got to treat each situation for what it is, all right? We're going to try to go through the bad scenario in our next class. But in this class right now, let's stay on the narrow path that we're on. Let's treat them with respect and get respect back from them. Let's not have to go through making counterclaims and all those things because it's time consuming. And even though it's not a court expense, it's still going to cost you money. You got to serve everybody. You got to get your paperwork prepared. You got to certify everything and get it off and do the tracking. Do all these things, okay? And it's a process. Again, you do your first thing you do is you do your notice, claim, notice of civil action, whatever, counterclaim, whatever it is, and then they like to shine that on. So more than likely, in almost every circumstance, you're going to have to do a what? A notice of fault and opportunity to cure. They're going to shine that on too. And if they've ignored that first one, you can almost carry it to the bank that they're going to ignore the other one. That's where they made their fatal mistake, because now you have given them every benefit that is entitled to them by law, okay? And this is their law, the corporate law, not to mention the common law and God's law. But their law says the same thing. So what do you do next? You do your default judgment. You issue a default judgment and you send that to them again, certified mail. Now, when you get a default judgment from the day they get it, they have 72 hours to respond to a default judgment. If they fail to respond, what you do is you contact the local sheriff, wherever they're doing business or they're living, wherever it is. You contact that sheriff. You send them two things. You send them the notarized default judgment, and you send them a 10-day notice to what? To settle. You give them 10 days to settle whatever that judgment is for. Let's say you got a judgment against them for $100,000. They got 10 days to come up with $100,000. They had the chance to get you down to from 100,000 to 10,000, but they didn't. So who put themselves in that position? They did. How did they do that? Because you did what you need to do to protect yourself as the injured party. Listen here, Roger, if I break your arm and I do it intentionally, and I say, well, Roger, I'm awful sorry I did that. I won't do it again for another month or two. So I think it's worth $500, and I'm gonna give you $500. Is that right? No, it's not. You know why? You're the injured party. You're the one that sets the damages, not the person that injured you. So you ask for what you want, and you might as well put it up there where you want it. I mean, I just got through asking for somebody $10,000 a day from each one of the people involved. Why? Because they wouldn't respond? Yes, because they wouldn't respond, and I gave them every damned opportunity to do it. Now they have their default judgment. I mean, their fault and opportunity to cure. They haven't sent one single word, but they still have a little time. So we're going to give them some time. We're going to give them a couple of extra days even. Because when you go to that county recorder and you want to record it, or you want to record it in a county court somewhere, that time you gave them is more time than what they are allowed by law, and not only that, but by their own law. You know, you see what I'm saying? So the more time you give them, the better off you are when you're going to finally get that thing recorded. So the next thing you're going to do when that sheriff goes out there and he serves that default judgment and that notice, okay? Now, they have 10 days to make an offer to you to settle that is acceptable to you, or they can in writing request a 10-day extension, and you will have to grant them that 10-day extension, okay? At the end of that 10-day extension, if they have not made an acceptable offer, the next execution order you're going to do is you're going to give the sheriff an execution order to do what? To go out there and start collecting on your judgment. That means the first thing the sheriff is going to do when he gets there, if there are cars in the driveway, he's going to take and tag that car, and he's going to put a tape around that car because he no longer owns that car. Okay, it's your car, and he's going to start collecting everything that person has got, except for the 7 items that you cannot take, which includes their Bible, marriage license, all those kind of things. Okay, we went through this before, but you're going to get a complete list of this. Because every one of these steps I'm giving you right now, I've done time after time after time. Now, I do somewhere in all this system have some blank copies where you can edit them and put the information, your information in. So I'm going to make sure that everybody gets this, and it's all done, mine are done in Word format. The ones that you're getting are the ones that I scanned in, and you're getting those, I believe, from Anna and from Alan are in PDF format, okay? But however, if you have a PDF draw and conversion, you can edit them as well. I do have draw, so I can edit mine. But the point I'm making is I want to make sure that you get a complete sample of the document. Now, on the document that you're going to get that says notice of lawful civil action against the named, the herein below named defendants, respondents, because that's what you're going to call every one of them, because that's what they are. So that's the document that I'm going to use, and if it's a counterclaim, it's a notice of counterclaim, and it's that simple. You just tailor that document to fit whatever your need is, okay? And if it's just a notice of claim, let's say there's nothing to counterclaim, so you make a claim against somebody because they've injured you or damaged you in some way. And remember, you don't have a claim if you're not a victim. And you're only a victim if you have a loss or an injury. Now, that loss or that injury doesn't necessarily mean monetary loss or monetary injury. It could be a physical or emotional or traumatic injury. That's an injury, and that's covered under their law as well. So I will be passing out the actual laws as well, and I think I've already sent some of those, and I think you should have some of those already, okay? Like, for example, debtors' rights. I hope everybody got that, because they are the debtor and you are the creditor, but you need to know what their rights are. And they already know better than you what their rights are. The reason why I sent it to you is so that you don't overstep what your authority is. You want to act under your authority. You don't want to usurp your authority either, okay? This is very important to understand. So now the police officer has gone his way. This is a good case scenario now. I mean, you've done what you've done. You've been polite. He's given you your citation. You're going to take it. You're going to take it to get it fixed and let somebody sign off on it that it's fixed and send it in, and it's done. You're done. Like I said now, if it's a belligerent situation, we're going to deal with that in the next class, because that is a total different kettle of fish that we're going to open up. And that can of worms is a real can of worms, because there's so many things can happen, including personal injury or worse. Because you have people out there wearing a badge, carrying a gun that should never have a badge, let alone a gun. And they will hurt you. That's some of them, that's their goal. They intend to do just that. But we don't have to play into their game. Even in a bad case scenario, there are ways to handle that too. And that might mean that you may have to flee and drive up to a police station somewhere, or a sheriff's office, or a jail, or any place else. You may have to drive there and let them follow you there, because you want witnesses to what this maniac is going to try to do to you. But we'll cover that next time. So right now, I pray that I've given you the thing that you need to deal with this peaceful situation. So Alan, if you will, please, sir, will you now start taking some questions?
absolutely.
Richard, but your camera has moved a little bit. We're only seeing maybe 50% of you. You
Oh,
need to
I'm
move.
sorry. I'm sorry. I got you on my big television my son bought me here because I can see everybody better than this little laptop I'm looking at over
Oh,
here.
okay. All right.
All
Well, it's
right.
much better when we see all of you.
Sorry
Okay.
about that.
All right. We do have a hand up. The first one is Beth Doyle.
Okay.
Good evening. Thank you, Alan. Hi, Richard.
Good
A
evening,
couple,
Beth.
thank you for all this great information. I have a couple questions, pretty short. Is it possible to rescind a signature on the power of attorney when you've purchased a car and get your MSO?
Well, first of all, ma'am, you would not sign a power of attorney.
Well, understand, I'm
want to-
saying one in the past, not an upcoming purchase, but one you've already made.
What's in the past is in the past, but there is a way for you, but let me tell you that there is a way to remove that from the state. How you do that is you take your vehicle and the documentation that they gave you for that vehicle to a port of entry. You remove it from the state that it is registered in to a different state. That state is your state. That is your last name. And you can only do that at a port of entry. That's the only lawful way to remove a vehicle, a boat, or anything else once it's already registered in a state. You have to take it to a port of entry and remove it from that state into your own jurisdiction, which is your last name. You're moving it, in this case, the state of Doyle. Mine was moved into the state of Warren. That's a used vehicle that I purchased, and that's how you do it. You take that and the documentation, and you take with you something to remove the license plates from your vehicle if it has license plates on it. Because when you go to that port of entry, you need a tool, because you're going to have to not only surrender the state documents to the port of entry, you're also going to have to surrender those license plates because they're not yours. They belong to the state. When you leave that port of entry, you will have no documentation except the documentation which you have prepared to remove it to your state, and you're going to put that in your glove box, and they will give you a removal notice, okay, which will have a removal number on it. That's how you take it out of that state's jurisdiction into your jurisdiction.
Wow, wow.
You understand that?
Yeah, it's a process. I guess just next time we won't purchase a car the old way.
Well, I pray that you don't purchase a car the old way ever again. You know the right way now to do it,
Well,
okay?
thank God for you and all this good information. Last quick question is, you talked
Next
a lot
question,
about.
Alan.
Yes. We have Adrian.